Another day, another story. Section 24 of Criminal Procedure Code. Public prosecutors. 1. For every High Court, the central government or the state government shall, after consultation with the High Court, appoint a public prosecutor and may also appoint one or more additional public prosecutors, for conducting in such court, any prosecution, appeal or other proceeding on behalf of the central government or state government, as the case may be. 2. The central government may appoint one or more public prosecutors for the purpose of conducting any case or class of cases in any district or local area. 3. For every district, the state government shall appoint a public prosecutor and may also appoint one or more additional public prosecutors for the district, provided that the public prosecutor or additional public prosecutor appointed for one district may be appointed also to be a public prosecutor or an additional public prosecutor, as the case may be, for another district. 4. The district magistrate shall, in consultation with the sessions judge, prepare a panel of names of persons, who are, in his opinion, fit to be appointed as public prosecutors or additional public prosecutors for the district. 5. No person shall be appointed by the state government as the public prosecutor or additional public prosecutor for the district unless his name appears in the panel of names prepared by the district magistrate under subsection 4. 6. Notwithstanding anything contained in subsection 5, where in a state there exists a regular cadre of prosecuting officers, the state government shall appoint a public prosecutor or an additional public prosecutor only from among the persons constituting such cadre, provided that where, in the opinion of the state government, no suitable person is available in such cadre for such appointment, that government may appoint a person as public prosecutor or additional public prosecutor, as the case may be, from the panel of names prepared by the district magistrate under subsection 4. Explanation. For the purposes of this subsection, a regular cadre of prosecuting officers means a cadre of prosecuting officers which includes therein the post of a public prosecutor, by whatever name called, and which provides for promotion of assistant public prosecutors, by whatever name called, to that post. B. Prosecuting officer means a person, by whatever name called, appointed to perform the functions of a public prosecutor, an additional public prosecutor or an assistant public prosecutor under this code. 7. A person shall be eligible to be appointed as a public prosecutor or an additional public prosecutor under subsection 1, or subsection 2, or subsection 3, or subsection 6, only if he has been in practice as an advocate for not less than 7 years. 8. The central government or the state government may appoint, for the purposes of any case or class of cases, a person who has been in practice as an advocate for not less than 10 years as a special public prosecutor, provided that the court may permit the victim to engage an advocate of his choice to assist the prosecution under this subsection. 9. For the purposes of subsection 7 and subsection 8, the period during which a person has been in practice as a pleader, or has rendered, whether before or after the commencement of this code, service as a public prosecutor or as an additional public prosecutor or assistant public prosecutor or other prosecuting officer, by whatever name called, shall be deemed to be the period during which such person has been in practice as an advocate. Section 25 of Criminal Procedure Code. Assistant Public Prosecutors. 1. The state government shall appoint in every district one or more assistant public prosecutors for conducting prosecutions in the courts of magistrates. 3. 1a. The central government may appoint one or more assistant public prosecutors for the purpose of conducting any case or class of cases in the courts of magistrates. 2. Save as otherwise provided in subsection 3, no police officer shall be eligible to be appointed as an assistant public prosecutor. 3. Where no assistant public prosecutor is available for the purposes of any particular case, the district magistrate may appoint any other person to be the assistant public prosecutor in charge of that case, provided that a police officer shall not be so appointed, a. If he has taken any part in the investigation into the offense with respect to which the accused is being prosecuted, or b. If he is below the rank of inspector. Section 25A of Criminal Procedure Code. Directorate of Prosecution. 1. The state government may establish a Directorate of Prosecution consisting of a Director of Prosecution and as many Deputy Directors of Prosecution as it thinks fit. 2. A person shall be eligible to be appointed as a Director of Prosecution or a Deputy Director of Prosecution, only if he has been in practice as an advocate for not less than 10 years, and such appointment shall be made with the concurrence of the Chief Justice of the High Court. 3. The head of the Directorate of Prosecution shall be the Director of Prosecution, who shall function under the administrative control of the head of the Home Department in the state. 4. Every Deputy Director of Prosecution shall be subordinate to the Director of Prosecution. 5. Every public prosecutor, additional public prosecutor and special public prosecutor appointed by the state government under subsection 1, or as the case may be, subsection 8, of section 24 to conduct cases in the High Court shall be subordinate to the Director of Prosecution. 6. Every public prosecutor, additional public prosecutor and special public prosecutor appointed by the state government under subsection 3, or as the case may be, subsection 8, of section 24 to conduct cases in district courts, and every assistant public prosecutor appointed under subsection 1, of section 25 shall be subordinate to the Deputy Director of Prosecution. 7. The powers and functions of the Director of Prosecution and the Deputy Directors of Prosecution and the areas for which each of the Deputy Directors of Prosecution have been appointed shall be such as the state government may, by notification, specify. 8. The provisions of this section shall not apply to the Advocate General for the state while performing the functions of a public prosecutor. Thanks for watching. Please subscribe for more videos.